morning. I want to welcome everybody to the office today. Very pleased everybody can make it for this very important and timely event. I think as many of you know, the Supreme Court tomorrow is set to hear Carpenter versus United States, where it will be asked to determine whether the warrantless acquisition of historical cell phone records over a 4-month plus period, collecting the location and movements of particular people, violates the Fourth Amendment. From our perspective, Google's perspective, we joined an amicus brief that we filed in this case because there are obviously very important issues that are raised in terms of the Fourth Amendment and privacy in the digital age, not the least of which is the vibrancy and viability of the third-party doctrine and the distinction that courts have traditionally made between content and non-content. And this is going to be one of those very momentous cases that the Supreme Court is going to be considering in the digital age. As many of you know, they considered the Wyden case a couple of years ago. The third-party doctrine, the distinction between content and non-content, these legal precepts, in our view, should not categorically foreclose protection under the Fourth Amendment. We'll be hearing diverse viewpoints from a number of panelists today. I want to thank CDT for organizing this event, and at this point, I want to turn it over to Greg Nojan, MC for today.
Gentlemen, auditorium. Gentlemen.
Thanks, David. My name is Greg Nojan. I'm with the Center for Democracy and Technology. For those who don't know CDT, we are a nonprofit, nonpartisan organization. We're based in Washington, D.C., and we have an office in Brussels. We're dedicated to keeping the internet open, innovative, and free, and to driving policy outcomes that result in that. We are a civil rights and a human rights organization. We work on a global scale. Thank you very much for coming. Thank you very much, Google, for providing this space. And thank you to the CDT Communications Department, to Brian, to Tim, and to Elizabeth for making this event possible. Our website is www.cdt.org, and today happens to be Giving Tuesday. So if you're in the mood for giving to a nonprofit group like CDT, go to our Facebook page. Your donation will be matched. Thank you very much. My piece of the CDT puzzle is the Security and Surveillance Project. That's what we nicknamed it. We're all about government surveillance and trying to make a world where the government must have a very good reason in order to surveil a person. Our priorities include reform of Section 702 of the Foreign Intelligence Surveillance Act and reform of the Electronic Communications Privacy Act. That's the 1986 law that governs the privacy of your email, of your chats, and of other information that you keep online. And that's why this case, the Carpenter case that David mentioned, and that is the subject of today's event, is so important to us and so important to your privacy and civil liberties rights. The advance of technology has meant that information that you used to store in your desk drawer is now stored with third parties companies that facilitate your communications or facilitate your purchases. Companies like Google and Facebook, companies like Verizon and AT&T that help you communicate with your cell phone. If law enforcement wanted to gain access to your information in your desk drawer, they would have to go in front of a judge and get a warrant. They'd have to prove strong evidence of crime, probable cause. But today, when the information is held by third parties, the third-party doctrine that David referred to might mean that they don't need that warrant. And that's why this case is so important. The court is being asked to decide whether cell site location information can be accessed for over 4 months without a warrant. And the court's decision will say a lot about the scope of our Fourth Amendment rights in the digital age. Today's agenda is compact. We'll have some kickoff remarks from Senator Wyden. We'll turn to an expert panel, and then we'll have a Q&A. Please save your questions for the Q&A. We are live streaming this event on Facebook. If you don't want people to know you are here, you might not want to ask any questions. If you stay here, you have consented to being in the live stream. So I want to thank Senator Wyden for coming today. and for all the work he's done on privacy and technology issues. He has been the go-to senator on privacy and tech issues. He's always there when you need to stop something really bad or you need to push something forward that's really good. Senator Wyden is the U.S. Senator from Oregon. He's the ranking member on the Finance Committee, and he sits on the Senate Intelligence Committee, where he does most of his work on these issues. Senator Wyden is the author of the GPS Act, S395. This is the bill that would require warrants for law enforcement access to location information for criminal investigations. He is a relentless advocate of civil liberties. His defiance of the national security community's abuse of secrecy forced the declassification of the CIA Inspector General's 9/11 report, shut down the controversial Total Information Awareness Program, and put a spotlight on both the Bush and Obama administration's reliance on secret law. Wyden has led the congressional fight against unnecessary and invasive government surveillance programs. Ron Wyden holds a bachelor's degree with distinction from Stanford, and he earned his law degree from the Oregon School of Law, and we are really grateful for his work and really pleased you could be with us, Senator Wyden. Thank you.
Thank you. What an inflationary introduction. And I don't want to make this a full-scale bouquet tossing contest, but I do want to talk for a moment about CDT and what an important role they played. When I came to the Senate in 1996, virtually no one in the Senate even knew how to use a computer. People used to joke that maybe Pat Leahy was the only person who knew how to use a computer. And the late night comics were having a field day with the United States Senate because they would say things like, you know, up on the Hill, they're calling the internet a series of tubes. And it just went on and on. And I got there and had a chance to be part of the group with the good counsel of CDT and Jerry Berman and so many others to write some of the foundational principles of an open and free internet, Section 230, making sure we didn't have 10,000 jurisdictions taxing internet access, for example. And so I just want everybody to know that this is not a new interest for CDT to be sponsoring this program. This is part of a multi-decade effort to really be, and I guess Greg called me the go-to. If I'm the go-to, the people that you all are hearing from today are the ones who advise the people who have the ability to go to issues and really come up with effective approaches. So big thanks to CDT. And we're going to make this a filibuster-free zone, so you're not going to have me go on and on. But I want to kind of set the backdrop for this case and how it relates to particularly some of the other things coming up here very quickly. The Supreme Court takes up tomorrow an issue that I think you ought to describe as the question of whether the government has a right to see where you have been every second of the day, where you eat, where you shop, where you sleep, all without a warrant. And it gets right at the issue Greg touched on, the 86 law. Now, there used to be some limits in terms of what the government could do simply because the technology didn't exist to let them go do it. Now, what we have seen is that if the government wants all kinds of personal information, it doesn't take a whole lot of effort. It doesn't take, big law enforcement agencies with a team of agents following everybody around, morning, noon, and night, home door, coffee shop, doctor's office, or the tavern, and it's not so expensive. It used to be incredibly expensive, and the government would have to put so much manpower on the case that it was prohibitive, and in a nutshell, tracking people used to really be a big lift. It was hard. It was no piece of cake. And that meant the government had to focus limited resources on the people who truly threatened public safety. Now, as Greg touched on, we've got just the opposite. Surveillance is easy, it's cheap. The government tells your phone company to hand the details over. Instead of a team of agents following a single target, now a single officer can track hundreds or thousands of people from the desktop computer. And given the fact that surveillance keeps getting cheaper, the bar is constantly being lowered for which Americans and how many Americans the government has the capacity, the resources, to actually go out and spy on. Moreover, our citizens can't count on the friction created by the limits of technology or government resources. They can't count on that the way you might have 30 years ago in order to protect your rights or prevent abuses by the states. So we need to embed those protections in the law, folks. That's really what this is about. If you're really going to protect people's rights, you've got to embed those protections in the law. And so we need the courts and the Congress to step up and make sure that our constitutional rights don't just vanish simply because technology makes it so easy to violate them. So that's where we get to the case of the United States versus Carpenter. If the government wants to peruse these extraordinarily intimate details of your life, should there be a requirement that they get a warrant? In the Carpenter case, and my guess is you're here because you're kind of up on a fair number of the details, the government demanded 127 days of location information, that's 4 months, 4 full months, from the cell phone carrier of Mr. Carpenter, without a warrant. The government lawyers have conceded that what you say in a phone call, the content of the calls, is private. But all the other information that your phone creates, including where you are every minute of the day, they argue are just business records, they're owned by the phone company, and the government can be in a position to get them with a much lower standard of proof than a warrant. The government argues, and this gets back to the 86 law that Greg touched on, that the Stored Communications Act of 86 gives it the right to this information without a warrant. Under the law, the government can demand location information merely by asserting that it is relevant in any way. Just get that, relevant in any way to an investigation. Relevant. Doesn't have to be significant. That, folks, is a very low standard of proof. Now, in 86, cell phones were the size of a Harry Potter novel. Cost a couple $1,000s. Used to see people on the sidelines of football games with these enormous things on their ear. I couldn't tell if it was blocking pads or a cell phone. But I can guarantee you that people who wrote that 86 law didn't imagine a scenario where every American carried a phone in their pocket or in their purse at all times. Read the law. The word location does not appear. Not once. There's no even reference to the location issue, which is now so central to people's privacy with the capacity of the government to follow you, essentially, wherever your location might be. But rather than ask Congress for the authority to track Americans' movements using cell phone records, the government just decided, oh, we've got that power already. Now, quaint idea, but that's not the way it's supposed to work in a democracy. We're kind of, sort of supposed to have laws written on these kinds of things, because that's kind of, sort of what the Founding Fathers had in mind. That's our democratic system of laws. Now, because of the government's decision to shoehorn new surveillance powers into old laws, there's a patchwork today of decisions and state laws which dictate how much protection Americans have from federal, state, and local surveillance. 7 states have passed laws requiring warrants for cell phone location, including Montana, Utah, Minnesota, and California. But of course, these residents only protect the residents of these states, do nothing to regulate the surveillance powers of federal agencies, and of course, really don't do anything to respond to the fact that what a quaint idea, people are moving back and forth all the time from various states. I mean, for example, in Portland, we've got lots of people from Vancouver, Washington, who love to come to Portland because we don't have sales tax. This is just not a reflection of the way a modern world and economy works. Now, multiple appeals courts have ruled that if police use stingrays or other cell-site simulators to track locations, it does require a warrant. And in 2012, the Supreme Court ruled in U.S. v. Jones that attaching a GPS device to a vehicle also requires a warrant. So now we've got a whole bunch of rules in different places. One set of rules for demanding information from a cell company, a different set of rules if police track phones themselves or use a tracking device. Different rules, but what is still very similar and very private, underline private data. My view is that we'd all be better off with a clear standard that says that the government needs a warrant to track an American's location. So former Republican Congressman Jason Chaffetz joined me in writing such a proposal in 2011. It says if the government wants location information from Stingray or a cell company or a car GPS unit, it's got to get a warrant. That way, Americans and law enforcement personnel alike, everywhere in the country, not just in the handful of those states, would know what the rules are. One rule, straightforward, understandable. My bill would also go after high-tech stalking by creating criminal penalties for secretly tracking a person's movements with an electronic device. And it would prevent companies from sharing digital location information without customer consent. Now, I think it would be fair to say that the congressional leadership, as of this morning, is not exactly tripping over itself to get this bill enacted into law, which is why CDT and so many good organizations are important, because this is part of how we get information out in a democracy. And I'm of the view that political change often doesn't start in government buildings in Washington, D.C. and trickle down. Very often, it's bottoms up. And that's, for example, how we finally got some checks in terms of the use of metadata. And we passed a law that basically didn't have the government going out and collecting enormous amounts of data on law-abiding people. We actually had some limits. Wasn't as far as I would like to go, obviously, but at least when people understood what was being done and that their government was not being straight with them, which that was very much a part of the questioning of James Clapper that I did in 2013, when he certainly didn't tell the truth to the American people about what the government was doing. You begin to get changes. Now, given the fact that the congressional leadership has not exactly raced to get our GPS law enacted, we have turned to the courts to decide the questions, and that brings us back to the pending Supreme Court case. the last several years, the court has started to build the argument, the case, that this kind of extensive digital surveillance, the kind that is at issue in Carpenter, does constitute a search under the Fourth Amendment. I mentioned U.S. v. Jones. Justice Sotomayor, concurring opinion, laid out a principle that I've talked about and I heard Greg touch about. She argues it's time to rethink the third-party doctrine. Basically, that's the principle that once you give a business information, there's no longer an expectation of privacy from the government. The justice wrote the approach is ill-suited to the digital age. You got it in half a sentence. That approach is just not suited for the times. And she went on to say that it was ill-suited for an age in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks, not exactly the people we associate with terrorist acts or other such matters. The justice argued that companies today collect vastly more information about Americans than ever before. Practically all of the intimate details of your life, according to her, now held by a third party. We know what they buy at the grocery store and the pharmacy, who they call and text, what websites they visit, and so on. In 2014, the court went even further. In the Riley case, California versus Riley, they said a police officer needs a warrant to search the cell phone of somebody under arrest. The court unanimously ruled that cell phones contain such a vast amount of personal information that the old standards for searching people under arrest no longer apply. Now, I'm going to come back to this one because this was a hugely important decision. And the court basically said in that case, digital is different. Digital is different. And we're going to need a new set of rules to handle a new time. Here's how Justice Roberts summed it up. The fact that technology now allows an individual to carry such information in his hand doesn't make the information any less worthy of the protection for which the founders, fathers fought. His solution was simple. Search a cell phone, government's got to get a warrant. And that's how we get back to Carpenter and location data. Once again, the court's faced with a case where the government is trying to use old laws to justify demands for massive amounts of personal information without a warrant. In my view, there should be a single, simple standard for the government to track somebody, and we ought to just have a few words behind it. Just, period. Get, period. A warrant, period. And I don't think we ought to let too much cloud the basics of what I've just described, because that's really what this is about. Getting a person's past movements from the cell company, tracking their movements in real time with a GPS device. Just get a warrant. If this was a political rally, I'd say, all right, I'm calling it out. Just get a warrant. I'm going to spare you that because of my respect for the senator's non-political. I'm going to conclude with just one point that I thought about coming up. I won't take but a minute on it. A big part of this revolves around what my wife and I are older parents. We have twins that are 10, a little one that's 4. And from time to time we say to Scarlet Willow Wyden, brightest red hair on the planet, we say, Scarlet, just because you can do something doesn't mean you should do it. And we say, especially when you're asking for a third helping of ice cream, because Scarlet, you're going to get sick. And in a sense, when it comes to surveillance and spying on our own people, the Fourth Amendment serves the same purpose. It says the limits to invading the lives of our people aren't set by what's possible, folks. They're set by the Constitution. And I want to leave you with this. The Constitution is strongest when it has a lot of friends. And in the next 60 days, it's going to need a lot of friends. And let me tell you what I'm talking about. Greg touched on the question of the Foreign Intelligence Surveillance Act, Section 702, coming up between now and the end of the year. I'm supportive of the idea that there are threats overseas. No question about that. If you've served on the Intelligence Committee, as I have for a while, no dispute about that. But there shouldn't be an end run on the Constitution when it comes to the rights of law-abiding Americans who may be caught up in those searches. And some of you may have noticed that we can't even pass legislation which would codify what Dan Coates said in an open session when I asked him, does the Foreign Intelligence Surveillance Act permit solely domestic collection? He said no. And I'm not going to talk about anything other than I've tried to get an amendment to codify that. We haven't been able to get it passed. So you get a sense of what kind of privacy rights are at issue here. I mentioned the border searches, the question of an arrest and a person not having their phone searched. That's coming up on the border. What is involved at the border, and some of these stories, and I think we shared some of them with CDT, really raise the question about during the Trump administration, are they going to say, their officials, that the rights of Americans stop at the border? That's what we're faced with. We're pushing back on that. And we're going to have some new nominees come in, and we're going to need strong advocates for privacy there as well. And finally, we've heard from the Justice Department that they're back in the business of wanting to change encryption rules. I don't know if any of you have heard this, but they're saying what they'd like to do is have a new policy of responsible encryption. Make no mistake about it, folks. Responsible encryption is code for allowing backdoors. That's what it means. And we all know what backdoors are going to do to the privacy rights of law-abiding Americans. So this morning we're gathered to talk about Carpenter and people's Fourth Amendment rights in the digital age. Over the next 60 days, we're going to have the same challenge of trying to find more friends for the Constitution as it relates to the Foreign Intelligence Surveillance Act, as it relates to searches on the border, as it relates to encryption. The Constitution is strongest when it has a lot of friends. And the reason I wanted to come this morning, when there's a lot going on with taxes and other things, is when I think about CDT and all that they stand for and they work for and the people they associate with, I said to myself, here's a chance to run with the right crowd. A crowd that understands our wonderful country, and the Constitution is strongest with a lot of friends. Thanks for what you're doing, and thanks for having me.
Join me again in thanking Senator Wyden. Before we proceed, I did want to take a minute and recognize CDT's Executive Director, Nuala O'Connor. Nuala, please wave to folks. Thank you for coming. And this event wouldn't be possible without Nuala's support. We're now going to turn to our expert panel. I'd like the panelists to go ahead and take their seats. I have the honor of introducing our moderator, Katie Bo Williams. Katie, you'll be right here at the podium. Katie Bo covers surveillance, terrorism, and congressional oversight of the intelligence community for The Hill, a newspaper that covers Congress. She used to cover cybersecurity for The Hill. While Katie spends much of her time staked staked outside of the House and Senate Intelligence Committee's secure spaces covering the Russia investigations. Her reporting also focuses on the policy debate on government surveillance authority. And we're really pleased, Katie, that you could join us today and help these panelists show how expert they really are.
Thank you for that, Greg. Although we are here today to talk about this specific case and the potential legal ramifications of the Supreme Court's decision here, technologists, civil liberties advocates, and others see a pretty clear space here for Congress to weigh in and address some of the more granular policy questions that this case raises in a smartphone age. One of the laws that the government is relying on the case, the Stored Communications Act, which you heard Senator Wyden refer to, was updated in part in 1994, but in many ways hasn't been touched since 1986. At that time, there were 1,000 cell sites in the United States, and less than half of 1% of Americans had a cell phone. Today, according to the ACLU, there are more than 300,000 cell sites, and 95% of Americans have one of these in their pocket. Since 2010 and 2011, when Carpenter's data was collected, cell providers have also started saving location information for text messages and data connections in addition to calls, even when a phone is sitting in a bag or a pocket, checking for emails or weather updates. It's a different world. So I want to start today by talking about what kind of data we're talking about, how it's generated, how precisely it can locate a person. But before we get into that, let me introduce our panel. Ashkan Soltani is an independent researcher and technologist specializing in privacy, security, and behavioral economics. He's a former senior advisor to the U.S. Chief Technology Officer in the White House, and also served as the Chief Technologist for the FTC. David Bitkower is a partner in Jenner and Block's Investigations, Compliance, and Defense Practice, where he works on matters of data breach and cybercrime. He joined the firm after more than a decade as a federal prosecutor and was last the Principal Deputy Assistant Attorney General for the Criminal Division at the Department of Justice. Andy Pincus is a partner at Mayer Brown and sits on the board of CDT. His practice focuses on briefing and arguing cases in the courts, developing legal strategy for trial courts, and presenting policy and legal arguments to Congress, state legislatures, and regulatory agencies. Michelle Richardson is the Deputy Director of Freedom, Security, and Technology Project at CDT. She works to ensure that government programs do not infringe on privacy and civil liberties, and is a recognized expert on how post-9/11 security policies can impact constitutional and human rights. So Ashkan, I'm going to go to you first, but as we kind of go through this discussion, I want everybody to feel like they can jump into the conversation as needed. Ashkan, talk to me about the kinds of data that we're talking about in the Carpenter case. How that information is generated.
Sure. So I'm sure a lot of people are familiar with this already, but just to recap.
I was going to say, one is that.
Great. So most people are familiar with how cell phones generally work, but just to recap, your cell phone typically has connectivity through a cell tower. This is and basically an antenna that your telecom provider, your cellular provider, places in various locations. We know there's approximately 300,000 of them in the U.S. And just by virtue of your phone being on, it's communicating to that tower and essentially revealing the phone's distance and direction from that tower, right? And so that information alone is enough, and it's the kind of what we're talking about in Carpenter, is enough to approximate the location of the phone. And the tower densities will also vary. So some studies have been done by some folks at the University of Washington, where in some cities like Seattle and Milwaukee, that tower density can be something like 12 towers per square mile. So each tower gives a range of 1/12 of a mile. And furthermore, each tower has 3 directional antennas, so you can further divide or subdivide that location by a third because you know the tower and the direction of the phone. And so that in general is what we're talking about cell site location information, which is the location of the cell site or the distance from the phone from that cell site. We also have other ways to locate people with cell towers where we can triangulate the phone, for example, and use multiple towers to get a more precise location of the phone, and that gets better and better granularity. And then there's a variety of other technologies used to track individuals outside of towers, right, that would be a location. And I thought, we can get into this a little bit more, but I thought Senator Wyden's comments about focusing on location rather than just cell site location as a app one, because we can get location from GPS, we can get location from wireless Wi-Fi antennas, we can get location from, say, Bluetooth antennas. So if you have a Fitbit and there's a sensor, which we have in this technology called mobile retail tracking, right? So here in DC, we have companies like Sweetgreen that will log when your device walks by or goes into a Sweetgreen store. That's essentially revealing to Sweetgreen that you passed by, and therefore Sweetgreen has a location history of everyone that went by that store. So we have various ways to describe location, and I think it's important to focus on that aspect of the physical location, not the technology used, whether it's cell phones, Fitbits, facial recognition, for example, could reveal your location, etc.
I mean, how precise are we talking about here? When you talk about walking past the store, the cell site location data, if you were to narrow it down to the technology, how precisely can somebody be located, and how has that changed since Carpenter himself was walking around with something in his pocket?
Sure. So pure cell site location, as I said, will depend on the density of cell sites in a city. So right now, in major cities, we might have, say, 12 towers per square mile. As we roll out 5G, but according to former FCC Commissioner Wheeler, we're expecting to have millions of towers to roll out 5G, which is 5 gigabit cell phone connectivity. So at that point, that precision is even going to get more and more precise, right? So we're just going to see just cell tower-based geolocation become more and more precise, right? But we also have other factors that if you want, in the case of not Carpenter, but other. So did folks see there was a recent story this last week around Thanksgiving and how people spent their holidays in Thanksgiving? This is around voting patterns and across family lines. If you have family members that are in different political parties, it was kind of a funny story. It was based on a company called SafeGraph. And so what was interesting about that story is some researchers at, I think it was UW and UCLA, got information from a company called SafeGraph. They got 7 trillion records of 10 million subscribers, precise geolocation information around Thanksgiving of last year. And they were able to make some inferences around whether you have different political parties and you spend Thanksgiving together or not. But what's interesting is they got precise geolocation from a GPS on cell phones from a third party, right? And that would also fall under third-party doctrine, right? And this is 7 trillion records from a small company no one's ever heard about, with probably a third of the legal team that T-Mobile or Verizon will ever have, if that, right? So we can talk very precise geolocation across a bunch of different technologies. In Carpenter, it was cell site location, but I think it varies to the type of information we're talking about.
And I want any of our other panelists to feel free to kind of jump in here, but the sort of jumping off point that I'd go to is from a privacy perspective, how invasive is this kind of collection, and what are the implications for individuals' privacy? And anybody can kind of jump in if they want.
Well, I think the thing to recognize about location information is it tells people's location with varying degrees of precision, increasing amounts of precision, but that location data can be analyzed to determine a lot about an individual, whether they're sick, what their religion is, what their political party is, who their friends are, what clubs they belong to. If you have 127 days of someone's location, that reveals a lot of personal information about the individual, and that was the basis for the court's decision in the U.S. v. Jones case that Senator Wyden referred to about GPS tracking. What the court said, or what at least 5 justices concurring said, is that information allows the inference of so many personal details about someone that it's something that we should want to have some check on the government being able to get it, because it's not just the location, it's the inferences that can be developed that are so critical.
And I've got a couple of questions. I think we'll get into the Jones case a little bit more later, but David, I want to go to you next, because I want to talk about how law enforcement uses this data. How important is location information in criminal investigations, and how would law enforcement be affected if a warrant was required for accessing lengthy period of stored cell site location information?
Sure. Let me start by thanking CDT and for having us here. and say I'm going to try to do my best to articulate what I think the government's views are here. I don't obviously speak for the government now, so they're a little bit disturbed by having me being the mouthpiece for them, but I will do my best to articulate based on memory and also current views as well to a degree. So location information, like any other evidence, can be very valuable in a particular case. In the Carpenter case is a really good example. You have a case where there was a string of armed robberies, and there's a question as to who was present at those various armed robberies committing them. And so you can try to solve that case with eyewitness testimony. That's often difficult in an armed robbery scenario, like in many other scenarios, because people wear masks. It's difficult because eyewitness testimony is comparatively unreliable compared to digital evidence. And it can be difficult for lots of other reasons. Whereas cell site information, and just to back up a little bit, I don't disagree with Ashkan's description of technology as it exists and as it's moving forward. The cell site technology at issue in the Carpenter case was not nearly as precise as what Senator Wyden was talking about, what other folks have talked about today. It narrowed down location to an area between 3.5 and 100 million square feet. In an area roughly where there were at least 1,000 buildings of different types, several different houses of worship, who knows how many restaurants, lots of stuff. So we're talking about a relatively broad area, and based on information from an informant that Carpenter was present at one or more of these robberies, the government was able to get a few months of cell site records which showed that he was in fact hitting off of cell towers in the general vicinity of those robbery locations at the general time of those robberies, which obviously is strong evidence, and he went to trial, he denied it, and he was convicted of the robberies based in part on that evidence. So cell site evidence and other location evidence can be very valuable. In that scenario, we have a suspect and someone is alleging that they're guilty of a crime, and you want to either rule that out or rule it in and corroborate what the other witnesses are telling you. It's also valuable when you don't have a suspect. So for example, there could be an armed robbery with no suspects at all, there could be a murder and you don't know who's present. Often law enforcement will get what's called a tower dump, which is discussed in some of the briefs in the case, where they'll go to the nearest cell site of the different companies and say, so this murder took place at 12:31 p.m., give us a half hour before and a half hour after, and give us a list of the phones that pinged off that cell tower during that period of time, and then they can get subscriber records for those phones. Let's say it gives you 100 or 1,000 phones, depends obviously on the neighborhood and time of day and the like, and then say, well, look, we have subscriber records for someone. This person actually has 3 prior convictions for armed robbery. Perhaps they're someone we should look into more. Or the jealous ex-husband was present, and even though he lives in another city, and that's something we should follow up on. So it's a way of corroborating evidence in a way that I think is socially useful, and it's also a way of generating leads in the first place. Now, no one's talking about making that off limits from law enforcement, so it's not like the result of the case will mean that that evidence is not available. And current law, so the law that Carpenter's challenging, doesn't give the government free rein to ask for this information or demand it from a company, nor does it require just a subpoena standard, which is a relevance standard. It requires a standard somewhere in between relevance and probable cause. It requires showing specific and articulable facts to show that it's relevant and material to an ongoing criminal investigation. In reality, that standard is not tremendously different from a search warrant standard in my experience. You have to have facts that show that this is relevant. You got to take it to a judge and get the judge to agree that those facts make it relevant, and it's got to be material, so you can't do an open-ended fishing expedition. So it requires more effort than a subpoena, it requires more predication than a subpoena, and it allows you to get the evidence if only if a judge agrees with you. The Carpenter case is a good example. In that case, they had an informant who said Carpenter was present at the robbery scene. That's sufficient to get a search warrant, and so they probably, in that case, could have gotten a search warrant. Probably would have taken all that much more time, maybe a little more time. If there's an armed robbery with no suspects, I think it's pretty straightforward to say the cell tower dump will probably yield evidence, and you probably could get a judge to sign off on a search warrant for that. So elevating the cell site location standard from that relevant material standard to a probable cause standard probably doesn't kill law enforcement, probably doesn't advance the interests of people who are trying to stop law enforcement getting that record. Probably doesn't make that much of a big difference. There certainly are edge cases where it would make a difference. And just to give you one example, I tried a murder case several years back where there was a murder committed. The police had some suspects, but they didn't have probable cause that anyone was involved in the murder. And at the time, records were kept for a shorter period of time, about 6 weeks instead of about 6 months, is what it is now. And so the detectives were able to get cell site orders for several of the leading suspects. Probably didn't have probable cause. It's hard to go back in time and say what a judge would have concluded, but probably didn't have probable cause that any of them were guilty. Got those records, and then over the course of months built up a case. And those records actually showed that 2 of the potential suspects had traveled from Sunset Park in Brooklyn to Queens along the BQE, roughly, to where they found a burned car where the victim was killed. And that wound up being tremendously important evidence to narrow down the suspects, to get one of them to confess, later to build a murder case in which several people were convicted. I'm not here to tell you that wouldn't have happened had a probable cause standard existed or had that not been available. It's really hard to unpack those things. I think it's fair to say that if the standard for this kind of evidence was raised to a probable cause standard, there would be cases of violent crime that were not solved. There'd be a little more crime. There'd be cases that are solved with a little more effort, a little more expenditure of resources by law enforcement. And probably more importantly, there are simply cases where the police wouldn't resort to this type of digital evidence. They would resort to other types of investigative techniques that don't require a warrant or require a lower standard, like interviewing people, using informants, using the grand jury process to call your associates or your employer into the grand jury to ask you questions. And so one thing I think we should come back to in this debate is I think it's very easy to mistake making things harder for law enforcement with advancing privacy. And I think in particular when we're talking about digital evidence, that's often backwards. And often I think people who love privacy and people who believe in accuracy and liberty and getting the right people for the right crimes probably got to be a little more open to the use of digital evidence as opposed to other types of evidence which currently require a lower standard. So when we're setting standards for these things, we ought to think about not just whether they make things easier or harder for law enforcement, but the distributional effects and what we're asking law enforcement to do, what the mission is we're asking them to do, what the tools we're giving them to do it, and which ones we want to encourage them to use, consistent with our notions of privacy and also accuracy.
Ashkan, I think you had something you wanted to add to that?
I just want to clarify. So I absolutely agree that information is useful. I think one of the challenges is articulating the different types of digital information and treating them the same. So you earlier made an example of, in the case of Carpenter, the cell tower location had up to thousands of square feet, including churches, homes, drugstores, etc. The question is, what would be the standard required to go and search each of those places, right? For the people present at those places, right? Since when you request with a single request a cell tower dump of everyone approximate to that, you're essentially getting information for all of those people at all of those locations, right? And so if you can do that with a single request, that's a much lower standard than what it would be to go to each of those locations and search those out. Would they not?
So I guess it depends what you mean by go to those locations. If you're talking about searching someone's house,
yes,
it would require
right.
probable cause.
So you need search warrants for each?
That's right. For every house you wanted to search, or at least one warrant that had probable cause with respect to each different location you wanted to search.
Right.
If you wanted to go ask the store owner who had come by here and show them photographs, that would require zero predication. If you had a suspect like Carpenter and you wanted to go to his place of employment, I don't know if you had one, and say, was your employee present at work at this hour, or were they maybe at the scene of an armed robbery? That's a very intrusive law enforcement interaction, in my view. That requires zero legal predication. And so that's what I'm talking. So when we think about cell site orders, just to give some scope, there's about roughly 100 to 200,000 done per year. The numbers are not easy to parse out. There's about 30 million car stops and street stops per year by law enforcement. Those give very precise location information. It's a police officer stopping you at a location on the street. Those are intrusive interactions. They're extremely precise, and they happen, 150 times more often than cell site orders. And frankly, the evidence that comes from them is not necessarily as helpful or necessarily as helpful to a jury. And so I agree with you. We absolutely have to take into account different types of interactions, but I do think sometimes people make the mistake of overemphasizing digital evidence abstracted from a larger view of what do we want our law enforcement to look like, what do we want them to do, how do we want them to interact with human beings, how do we want to solve crimes and things like that. And let's not think that if you raise the standard for cell site evidence to a probable cause warrant, what have you really accomplished, if anything? And I think not all that much. Perhaps you've done a little bit of damage.
David, I want to ask you about the time frame question. The ACLU is asking the court to essentially define an appropriate time frame for which this data can be accessed without a warrant. They're suggesting 24 hours. Is that a useful way of thinking about this problem from a law enforcement perspective? And is 24 hours the right time frame?
So again, it's very hard to answer that question in the abstract. You know, when you're doing an investigation, when I've done investigations involving cell-site evidence, sometimes a day is exactly what you need, and sometimes in the case of a string of armed robberies, it's 7 different days over 7 different weeks. And sometimes when you're trying to track a suspect for other reasons, you need a longer period of data. There's no question that longer period of tracking is more intrusive. There's no question you can find out more the more data you have. I think that's absolutely right. I don't think it's accurate. You can use cell-site information to find out where somebody ate or where they worshipped or whether they were sick necessarily. I think that tends to be an exaggeration, at least based on current technology. Not that you couldn't get there. But I think it's hard, and I think others will probably want to weigh in on this, I think it's hard for courts in the abstract to draw lines like that. I think those are areas where legislative input is probably more valuable and more flexible, because you could change based on changing technologies. So you could say 7 months of that or 4 months of that is too much. They should only get 1 month without a warrant. But then what if they combine a cell site order with a GPS for a day? And what if they combine it by interviewing 12 witnesses? And what if they combine it by getting your gas station receipts? But that requires only a subpoena, and that tells you exactly where you were. Your credit card statement, my credit card statement is probably way more revealing about my personal habits than my cell site information. My cell site information will tell you that I go to work, you know, probably almost as much as I should. Whereas my credit card records will tell you everything about what I buy and what I buy for my family. You know, your Netflix viewing history is probably, because most people consider that much more private. All of that stuff is at a subpoena level.
No, it's not.
No.
Well, so but your credit card records certainly are. You're not your video viewing history, but your credit card records certainly are, and that tells you a lot of stuff. And so, you know, perhaps you should say, look, these are more sensitive areas. We should raise the standard there, maybe. But then you also want to compare it to where you're driving law enforcement. So I think it's very hard for a court to say a particular time is too much. I think it's easier for Congress to say it. Or state legislatures, which have acted in this area, as the senator mentioned, and I think those are just difficult line drawing questions for a court to do in the abstract.
Michelle?
Yeah, and so we need the court to make the constitutional decision here, right? That's definitely a prerogative. But no matter what the court says, we're likely to need Congress to step in and clarify some of the details after the fact. Sometimes this case is presented as an up or down vote on the third-party doctrine altogether, right? But that is likely not to be what the court is actually going to hold. They're probably going to look at the data and make a decision, perhaps on the time, right, or the granularity of what was collected and who was holding it. And if a decision like that comes out narrowly, it might benefit law enforcement to have a statute that makes some clear rules up front, as opposed to letting the courts decide this on a case-by-case basis, right? And this is where something like the GPS Act really does come into play and would give more certainty, right? Would address location in different ways, because this case is just about the cell site location, and there are many ways to collect this information, a lot of different actors. And you want to think about things like time or granularity. Are we going to talk about stingrays too, right? So there's no third party in the mix and the government is collecting it directly. And then you have the question of whether we want to address just stored record or real time, right? That's not involved in this case. There is a cert petition filed in another case called Rios. The Supreme Court has not decided yet whether or not it will take that one this term also. That sort of certainty, you know, has been called for. Some people say the problem with this case is that it would throw criminal investigations into chaos. But worst case scenario, if we do not get Congress to act, it's absolutely appropriate for courts to make these decisions. We were trying to find examples in the Fourth Amendment where this has happened before, and so we found something like curtilage, right? This is the question of, is the space outside of your house protected by the Fourth Amendment and a warrant? And this was first recognized in the 1800s, but the courts have spent the last 150 years defining, what does that mean? Is it 6 inches? Is it 12 inches? Is it your carport or your porch? Is there a fence or a bush? And this is just in the Supreme Court again a couple of years ago. And they have put together some general contours of things to consider in each individual case. So it's possible for courts to do this in the Fourth Amendment space. They have done that before. And they can do this here if Congress doesn't act.
I just wanted to react to David's comment about privacy and what kind of information. You know, I think people's reaction to large amounts of information really goes to the question of how much information about you do you want the government to easily get. And the fact is, digital information is easy to get, and I think people don't have total trust that once it's in the hands of the government, it's going to be used for the proper purpose. I think we saw with some information about the NSA's data gathering that it had a big pool of data that was supposed to be used for one purpose, but people, you know, being who they are, use it for personal purposes. And so I think part of the concern here is really how much information do I want the government to be able to get easily about me without going through the kind of process that it has to go, that the Constitution requires. And I do think this aggregation is a big part of that. Even though it's true, interviews, you know, going to your employer and asking about you is intrusive, but it's a lot harder to do, and presumably the government isn't gonna invest those resources unless it has some reasonably good reason to do it, because it has limited resources, and that's a constraint.
Annie, I'm going to leave the mic in your hand because I want to turn to some of the options here for what SCOTUS might do. You obviously wrote the CDT brief in this case. How has the court handled tech cases recently, and what does that history tell us about how they might approach this case?
Well, as Senator Wyden said, talking about the Jones case and about Riley, the court has recognized that the availability of technology changes things and is something that has to be considered in applying the Fourth Amendment. It doesn't necessarily mean that everything that's enabled by technology is protected by the Fourth Amendment or requires a warrant, but the court has been very clear that in applying old rules, Riley is the classic example. And the issue in Riley, just to elaborate on what the senator said, search incident to arrest doctrine said if you're arrested, the government can search you, and that includes if you have an address book, looking through your address book, if you have a wallet, looking through everything that's in your wallet, and using that. And the government said, well, if I have a cell phone, if the arrestee has a cell phone, isn't it just the same thing? Why can't we just download the contents of the cell phone? Why is that different than looking through the address book? And the court said, well, it is different because pre-technology, there was a limit on the amount of information that the government was going to be able to get about you from the search incident to arrest doctrine. So the intrusion on the protection of the Fourth Amendment sort of had a real-world practical limit, and that limit is destroyed by cell phones, and we're not going to allow the contents of the cell phone to be subject to the same doctrine. So the court, I think that's the question that the court is going to be grappling with here. The big picture question, sort of abstracting from GPS for a minute, is the reality is there's lots of data, personal data about people that is now in the hands of third parties. GPS cell site location data is one of it, but take the most personal data. If you have a Gmail account, which since we're at Google, I hope everyone here does, the contents of your emails are stored on a Google server. A third party, in legal terms, has possession of your emails and has the right under the terms of service to look at them. And so the government has argued, it doesn't argue it anymore, but it used to argue that that meant that the third-party doctrine meant that the government could get the contents of your emails from Google without a warrant. That's pretty intrusive, and I think most people would say that's pretty outrageous. But so you have all of this information in the hands of third parties, and with cloud storage, photographs, think of everything that you have that's stored with some cloud service provider. All of those terms of service allow the provider to get to have access to that information. So if the third-party doctrine by itself means that the Fourth Amendment's protections don't apply, that would be a big change from pre-technology times when all of that information was kept in people's houses. So I think one of the things the court has to think about in this context, although this is a case about location data, is if you buy the government's broadest argument, third party trumps everything, what does that mean for all this other kinds of data? And I think the court briefs certainly highlight that issue, and the court will be sensitive to it. So then the question is, okay, if the possession of a third party by a third party isn't by itself dispositive, what are the factors that the court is going to look at? Is it content versus non-content? Is that the critical distinction? It seems hard to make that the distinction, because in Jones, the theory of the decision was, even though that GPS location data wasn't content, it revealed so much personal information that for the government to get it without that there was a reasonable expectation of privacy. So why wouldn't that be true, putting aside the lack of granularity? If this was GPS information in the hands of a third party, why wouldn't the rationale of Jones apply exactly? And then, does the court really want to get into the business of saying, oh, we're going to draw a line between GPS accuracy and cell site accuracy, when, as we heard, cell site accuracy has probably changed from where it was when the Carpenter data was gathered, and it's going to change even more in the next 2 years.
David?
Yeah, so I agree with, I think I agree with most of that, but I probably just draw a slightly different conclusion, which is to say, the third-party doctrine has never been as sweeping as people sometimes make it out to be. And it's always been the case that certain information in the hands of third parties can be accessed only with a warrant. And so an example being, webmail is probably a good one, because when webmail was originated, I think there was a general understanding that it was in the hands of a third party, it didn't get constitutional protection. A statutory scheme was enacted to raise the protections for certain, but not all, remotely stored email. But even after that, starting in about 2011 or so, with a couple of court decisions, the government made a strategic and policy choice based on the facts of cases not to challenge us, and to use warrants based on a probable cause standard to access webmail. And I probably agree with Andy. I assume I agree that if the government changed that policy and started to try to obtain webmail in ordinary circumstances from a provider like Gmail or similar providers with less than a warrant standard, they would probably wind up losing. And that probably is part of the consideration. So there are things like webmail. There are things like when you go to a hotel, obviously third parties have access to the entire hotel room. That doesn't mean the government can march in or even make an agent of the maid just because she has access to your room. There are things like GPS, as Andy says, look, GPS is held by third parties. You don't typically see the government accessing it with something less than a probable cause warrant standard. Now, partly that's because private companies don't store it the same way they do with cell site information, and it's not as typically kept as a business record. Partly it's because there isn't a clear statutory mechanism to do so, but that also reflects a judgment by Congress not to create such a mechanism. And so I think something like GPS, I think, had that if push were to come to shove in the courts, I think there would be a lot of willingness holding that is private enough and specific enough that even though it's held in the hands of a third party, in many, if not most circumstances, a warrant would be required. So I don't see Carpenter as sort of a watershed in the sense of does the third party doctrine exist or not exist. I don't think we're ever moving away from your neighbor saw you commit a crime, the police can ask the neighbor what happened. And so the question is what falls into that category of things that are private enough and sensitive enough that they should require a higher standard than a constitutionally mandated higher standard, and what falls into the category of things that you should be able to go ask the neighbor or the gas station or get the records that they wrote down as to what happened. Is cell site information there? 3.5 million to 100 million square feet doesn't seem all that precise. It doesn't really tell you anything about where somebody worships. GPS does, and so the question is should the court rule on a broad basis based on this record that there's something different, and how would they cabin that ruling to both the facts before them without sort of hazarding a rough guess at where technology is going?
Yeah, I think the one thing is, it's nice that the government's decided that it thinks it should get a warrant for the contents of my email, but I don't feel very comfortable that they could change their minds tomorrow. Lots of things are being changed in Washington these days, so I'd be just as happy for the Supreme Court to begin to lay down some guidelines that say, yes, you're right, just because the third party has it, that isn't a deal breaker for the Fourth Amendment, and here's a standard by which we're going to begin to sort out what is sufficiently private and what are the expectations of privacy sufficiently great that we're going to say you need a warrant versus not. And this case, as you said in the beginning, this is sort of a bizarre case because the statute already requires the government to go to a judge and to meet one standard. So the idea that the world is going to turn on whether it's this higher standard or not, I think you're right. On the one hand, how much more privacy will there be? But it's also very hard for the government to make an argument that this is incredibly burdensome when they have to actually go to a judge, meet a standard, and the question is just are they going to have to meet a slightly higher standard?
Andy, I want to ask you one crystal ball question, and then I want to turn back to the congressional issue and go to Michelle. As a court watcher, are you anticipating a fairly broad ruling here, or are you anticipating a ruling that is sort of narrow and kind of cabinet facts at hand?
I think the court has been very careful in the technology area to proceed cautiously. I think the court recognizes that technology changes quickly, and I think it's leery of laying down broad rules. There was a case that preceded U.S. v. Jones called Kwan that had to do with pager information, in which the court, there were lots of arguments about third-party doctrine and what the court should say about pagers. And the court very cautiously said, technology is changing. We're not going to issue a broad ruling here. We're going to issue a pretty narrow ruling that had to do with ruling the pagers and really didn't get into the technology and whether that had a Fourth Amendment impact. So I think if I had to predict, I think the court will be focused on, there are two things. It is going to have to say something about the third-party doctrine in general, because that issue is teed up, and the government, in its broadest argument, basically says that's the end of the case. My guess is they're going to say, no, that's not the end of the case, but they're also not going to say all information in the hands of third parties requires a warrant, and then they're going to say something about what the test is and why this particular information either does or doesn't require a warrant, and then there'll be lots of lower court litigation over how that standard applies to all the other information in the hands of third parties that we've been talking about.
Michelle, I want to go back to the question of Congress's role here. Do you anticipate that a ruling sort of more towards, basically in favor of Mr. Carpenter, is going to push Congress to step in and resolve some of these sort of broader questions in the smartphone age?
I think so, especially if it comes out, like Andy said, and will be targeted just at this case and leaves a lot of unresolved questions. That would be something that would encourage law enforcement to accept some sort of regulation here just for the certainty. As we all know, passing legislation is next to impossible these days, right? Especially if law enforcement opposes it. So I don't want to oversell the chances of a bill like this, right? It's very complicated. But if we are going to take on the third-party doctrine legislatively, I'm glad we're doing it with location. People feel very differently about location than they do about other types of records. And I think it would have the best chance of having Congress get involved. You could look to the states and the cities to see the privacy statutes they have passed in the last 5 to 10 years, and they are often location-based. Sometimes it's about cell phones, but it's about license plate readers, right? Or drones. And these are really just technologies that show you where people are, and people fundamentally get about why that is an invasion of their privacy. So I think there will be more political and public support for something like this that is really targeted at location, because it really just resonates with people in a way that trying to explain to them what their internet records just doesn't, sink in yet. Maybe the next generation, right? But right now people still need that visceral understanding of what this data means, and the location really gets to them.
Michelle, I'm going to ask you one more question, then we're going to go to Q&A from the audience. Can you talk to us a little bit, quickly, about CDT's involvement in this case?
Yeah, we were very happy to file a brief with the Supreme Court. This is an issue that we've worked on since our creation a couple of decades ago. And I think, we are hoping that the court at the very least starts thinking about the reasonable expectation of privacy in a really concrete way, applying it to specific types of records, I think is what we said in our brief. And instead of using it as a shield to categorically prevent courts from thinking about, is this data sensitive? What are the rules? How should we proceed forward? This is going to be like ripping off a Band-Aid, right? The government has had decades now of evading court review, and so this is not going to be easy. I was joking with David about who's going to bear the cost and how we're going to do this, but we have to start at some point, right? We cannot indefinitely allow government to collect all this data without meaningful court review. So hopefully this case will kick that discussion into higher gear.
Thanks, guys. Let's turn this over to the audience. Does anybody have any questions? If you've got a mic that we can bring you. Go right here first, and then go on back.
Thank you. If this hinges on the expectation of privacy, and now we have all, not just telephone companies, but all these different companies, Facebook, Google, Sweet Green apparently, tracking their location, then, you know, and we willingly sign away, you know, click accept on that prompt, and sort of what expectation can the court say that we have about our location if we're willingly giving our location to all these third parties?
So I think there's two ways to kind of carve it out too. There's a set of things by which you are willingly giving in the sense that you're going through a click wrap or installing an app or installing a service, and then there's a set of things that are passively collected without your information, right? So the mobile retail tracking that I was describing, or in-seat catchers, for example, these are technologies that you have no relationship to, might not even be aware of, and just by simply walking by, in the same way that a camera recording your face and doing facial recognition, these technologies do the radio wave equivalent of passively recording your activity. So one, there's a set of technologies that most people are not going to be aware of and have consented to, and the consent could be turning off your phone, for example, or powering off, putting on airplane mode, which does not work. And then to the set of also the knowingly consenting, I think the question is around the number of entities involved, right? So not just not simply by using a cellular carrier, you're sharing and creating a business record with that carrier, but you also have parties that they share with, parties, for example, when you install applications or operating system of your phone, will share with that operating system vendor and their third parties. And I think people will have different tolerances and awareness. I'm not sure that the reasonable expectation standard is the one to follow in terms of people's understanding of technology.
I was just going to say, you can have a party at your house and invite all your neighbors to come in. That doesn't mean the government can come into your house. They can ask your neighbors what they saw if they remember. But the fact that you make your house accessible to people you invite doesn't necessarily have anything to do with the government's right and your expectation of privacy vis-a-vis the government with those things. And so I think there's a lot of similarity with respect to apps and things where, Fitbit is a perfect example. People are sharing a lot of data via a Fitbit app, but I don't think anyone believes that data is going to the government or is going to be as available to the government as it is to Fitbit.
Go to our next question, which is Becky. It's a gray jacket feature. Sorry.
Hi, thanks everyone. This is a really great event. So I want to follow up on something Ashkan just mentioned, which is stingrays, even though we've mostly focused on cell site tracking, because MC catchers or stingrays, they really can be more invasive than cell site tracking, in that you don't just collect the location data of the target, you really in bulk scoop up the location data of everyone in a given area. So I'm curious, for anyone who thinks that there should be a warrant requirement for cell site tracking, do you think there should be additional requirements beyond the basic warrant standard for use of MC catchers by law enforcement?
So I'm not sure I caught the second half of the question, but so generally speaking, there's two different questions. One is, what does the law currently require? And there's a variety of court opinions out there. I think it's fair to say there's a commonly accepted understanding that if you're using a stingray or something else to put someone inside a private space, a warrant is certainly required. There's less clarity beyond that point. As a matter of policy, the Justice Department at a minimum has added a warrant requirement for their own usage, which is, again, it's a policy requirement, it's not a legal requirement. And different states, the ones who rely on Justice Department equipment and training, are more or less tied to that standard. The ones that don't are free to use whatever their own state law requires, which, as we've talked about before, in some states is higher, in some states is lower. I think as a policy matter, when you think about what the answer ought to be, I think it's appealing to say that when it gets very precise, like a GPS, and I'm saying a stingray can be much more precise than cell site location, because law enforcement can move around and track it and check signal strength and the like. It's more real time as opposed to historical, which makes it seem more intrusive. And so those things push toward a desire for having a higher process. As it gets less intrusive or less specific, then it seems more like actual corporate use of cell towers. And so the more along that path of sort of precision and real time you get, I think the more appealing it is to require a higher standard for law enforcement.
Anybody else want to weigh in on that? Chris, you've got the next question.
So, the conversation today has really been about sort of the front end protections that people are talking about. So, do we get a subpoena, deorder standard, or a warrant? But I think it's also important to think about the back end protections. And so, if the court holds that a warrant will be required for location data, I'd like the panelists to sort of look into their crystal ball and postulate as to whether we'll see further cases and further calls for the kinds of back end protections that courts have held are required for, say, wiretaps. So, after Congress passed Title III, the Supreme Court looked at the issue and said that a few additional things are required to make that kind of surveillance constitutional. Specifically, eventually that the target would receive notice, and eventually that there would be a minimization of innocent people's information. And in the context of location data, particularly for cell tower dumps where 99% of the people's information in the dump are innocent, right now, there's no legal requirement that the innocent people's information is wiped or deleted. And a couple of magistrate judges have required that, but that's really the exception rather than the norm. Likewise, although our hosts here, Google, today voluntarily notify individuals about government requests, the phone companies never tell their customers about surveillance. And so if the government obtains your location information, you will never, ever find out about it unless you're charged, which leads to this weird situation where the people who may be guilty of a crime get notified, but the innocent people whose information was swept up by the government never learn about it. And so, do you all see the back-end protections coming up, either in Carpenter or later down the road? And do you think that even if the court doesn't require a warrant, that should be requiring minimization of notice of location surveillance?
That's definitely necessary. This is a continual struggle, though, in all sort of investigative tools, and I think the government's legal opinion has been if they legally collect it for one purpose, they are allowed to use it for whatever they see fit later, which is incredibly scary. It's going to be a bigger problem, like you said, when they are intentionally collecting information on people they know who are not even relevant to the investigation, right? And I don't know how long it takes to litigate something like that. I mean, that's the other downside of doing this through the courts, right, is it takes years and years to revisit every single issue. And even if we win on the warrant issue, who knows how long it will be before the court comes back to something like that. That's why we need the legislation again. I would say, looking at things like the intelligence programs, Mr. Wyden spoke about 702 earlier, and some of the Homeland Security surveillance programs, we know that there are incredible amounts of data being collected, is being combined and cut in different ways that will be incredibly intrusive, and this will just be another layer of information on top of what's already in there. And hopefully this is something that legislation will address. I'm, not hopeful that the government will put those sorts of limitations on itself, and the courts will probably be many years away from enforcing that if they do.
So I think, sorry, I think the insight behind the question is an extremely important one. I think people tend to overstate the difference in precision that technology adds, but I think there is one of the ways where technology really is different is the persistence of information in the same state over a period of time. So I think the minimization question is a very important one. Data retention and standards for querying pre-existing data have probably a greater privacy impact than I think most people appreciate, and in many ways a greater one than the front-end requirements in the first place. That said, it's tricky because people get very upset when they find out that a crime was committed by someone who was already on the radar of law enforcement and dots weren't connected. And so you see that in the national security area. It goes without saying, this person was interviewed 8 years ago, why was that not communicated to the local police department? It happens when used in the domestic violence context. This is the third such complaint, and no one did anything. It happens in the child abuse context. It happens all across the board. And so, one area where citizens have been quite clear is that they don't want unnecessary walls against the sharing of information to people who should be sharing it. And so it's a challenge, and I think it's a challenge that courts are probably not, again, perfectly suited towards solving. But it is still a challenge that should be addressed in terms of saying how long should data be kept? Should it be kept of just the suspect as opposed to the innocent folks who are swept up in it? For example, on a tower dump, you see the same issue on stingrays. The gentleman who asked the stingray question, so federal policy now requires purging the information of the non-targets when it's collected through a stingray. Again, that's a policy choice and not a legal requirement. And so I think that's an important question, but it's a challenging one because it only takes one case where a connection is not made because data was purged or not shared or shared at a too high a threshold for people to get very upset and want that to be rolled back. Because at the end of the day, I think this goes to what we're talking about in general. Law enforcement, this is not a law enforcement versus the public question. Everybody is a potential beneficiary of law enforcement, and everyone's a potential person who's privacy invaded through investigations. But law enforcement as a whole has been given a mission by the public, and they've given a set of rules to follow. And so that they do is they go out and follow those rules. If you change the rules, it doesn't really hurt law enforcement. It's a question of what we want people to learn about ourselves and under what scenarios. So the question that Chris raises is a very important one. But if you err too much on the side of making law enforcement difficult, then you wind up at the end of the day sometimes doing more harm to privacy than you do by restricting the intake in the first place. So it's important to get the balance right, and courts are not always perfectly suited towards drawing those lines.
Along these same lines, I think so we've talked primarily about the point of collection and the point after collection storage. There's also kind of a blind spot with regards to the length of time companies store the records themselves and the way, under the third-party doctrine, the way they will disclose that information to law enforcement. I've worked as an expert on a number of cases, and the responses between companies vary dramatically in terms of what they provide to law enforcement with the same order, in terms of the length of time, the essentially amount of pre-processing or modification of the records the company will do to assist law enforcement. They'll often will do some really interesting stuff, additional queries, additional manipulation of the data, and there's no public discourse or public understanding of companies' different practices that will drastically impact kind of the privacy expectations that people have. Like you made the case that like real-time location information has a much more severe privacy impact than historical. I would argue that for some people, having 6 years of historical information has perhaps more than the fact that I'm here in a public venue now, right? So I think it will vary, and there's not a lot of focus or attention around companies' own practices with regards to law enforcement responses.
We're going to take one more question here in the back.
Maybe it's appropriate, the last question to be a little bit more philosophical. I've followed the digital privacy issue for a long time and have increasingly come to conclude if we put aside the market issues and we put aside wise policy issues and focus purely on the constitutional issues, that the basic problem is the standard itself. That what James Madison and his colleagues came up with was perfectly appropriate for the 17th century, the 18th century, the 19th century. But the reasonable expectation standard first puts a great burden on the judiciary to know exactly what is reasonably expected. Secondly, assumes that people have reasonable expectations because they know what's going on. And thirdly, tends to be tied to, I have a house with a door, I have clothes with pockets. It's got assumptions. So that the question I have is, since we, and it's also not hard to see many societies where your reasonable expectations of privacy were zero, where you had no expectation of privacy, and we may well be headed for that in a technological sense, that our expectations of privacy in the future will be zero, so that constitutional protection is nothing. So the question I have really is more philosophical. Have any of the panelists thought about the standard itself and whether there are other objective standards that might be used than the one that was written in the 1700s? Thank you.
Well, I'll be a lawyer, not a philosopher. So James Madison didn't think of the reasonable expectation of privacy standard. He had no idea that the Supreme Court was going to come up with it in the 20th century, which is when it first arose. But I think it's really, I mean, that's the phrase, but I think it is a surrogate for what realm of privacy is society prepared to recognize as reasonable. It's pretty clear it doesn't really depend these days on people's subjective expectations. It is, as the court itself has said, sort of circular, because, you know, your expectations, you know, how does the court know what people's even objective expectations are? So I think that it really ends up being a surrogate for the court, as it does in many other situations, what's due process of law, coming up with what is a standard what's the line that we should draw beyond which the government should require a warrant. You know, in the Kylo case, the case involving the use of a sort of heat sensor to look inside a house, the court basically said, you know, inside your house is really private. And it didn't do a survey, it just sort of determined based on history and logic that that's right. And that's also true in the GPS case. In Jones, the court basically said, or the concurrence written by Justice Alito said, you know, knowing every place that someone has gone with this level of precision gives you too much information about a person. That's really what the court ends up using as the surrogate. And, you know, given the other options, it's a pretty reasonable one, I think.
Well, thank you so much to all of you. I'm turning this back over to Greg.
Please join me in thanking Katie and the panelists. That was a really great discussion. Thank you all for coming here today. This isn't the last that CDT will be saying about this issue. We'll be saying a lot more. You can follow it on our website, www.cdt.org. Other organizations will be holding similar events going forward. I know that Verizon is planning one in February at which CDT will be speaking, and some other groups have indicated that they'll also be planning events around the Carpenter case. Again, if you want to follow it, our website, www.cdt.org. And don't forget, it's Giving Tuesday, and your donations to CDT will be matched if you go through Facebook. Thank you very much. Bye-bye.